Thanks everyone for coming along tonight. We really appreciate you coming along to Level 27 Chambers for our talk tonight on Insolvent Corporate Personal Trustees and Essentials. The recent decisions of Amron, Kalani and Lane bring into sharp focus the complex issues that may occur when a trustee of a trading trust or a responsible entity of a management investment scheme is placed into voluntary administration or liquidation. Also, of course, that applies to a personal trustee who goes into bankruptcy. These decisions, plus the ones before them, highlight the complexity of the issues involved, and in particular the diverse thinking of the judiciary. When you read these decisions, you'll see that just jumps out at you. For the reasons Mark and I will explain, to be available to trust and non-trust creditors. Can I just note, please, that a number of the nomenclature and the citations are referred to at the end of the slide. So, for example, we'll be referring to trust and non-trust creditors. As you appreciate, the creditors are creditors of the trustee, not of the trust, but we'll use a reference to trust creditors and non-trust creditors for simplicity. We're going to come to that in a minute, as there was some confusion in the judgment, which we'll deal with. One of the issues which arises from these authorities and others before it is what is right of indemnity, and in my lay terms, not technical, it's a bundle of rights and obligations. So it's really identifying what these are, which forms a large part of the decisions, actually analysing what this is, and particularly Mark will be dealing with that during the course of the talk. Can I just briefly go to this slide here, which identifies to understand what you get out of them. Because, as you'll see, Amron and Kalani were corporate decisions, Lane was a bankruptcy decision. With respect to Amron and Kalani, they only had traded as trustees, so they're only trust creditors. Lane had trust and non-trust creditors. Can I just pause there? Kalani, there was a recovery of a preference, but the counsel on both sides agreed to the position, and the court adopted that position for the purposes of the application. In Lane, there was an issue about preference. The decision's yet to be delivered on that. The next line, you can see the principal issues involved in it, particularly for re-emerald. What happened is the receiver had realised the assets, and the question was how are those assets to be. If I go to the next slide, Ameren is subject to a special leave application for the High Court. It's expected that to be heard in August. Mark and I have managed to obtain the application for special leave, which sets out the draft notice of appeal. We've identified in there the grounds of appeal, so you can take that away with you and look at it. Clarny, there's no appeal to our knowledge. Lane, there is an appeal that's been stayed, but again, there's still a decision left to be delivered on the preference issue as to how that's to be allocated. And I'll go a bit quickly to the first issue we're going to deal with, which is probably the fundamental background issue to these authorities and as well for the insolvent by wider terms than in the equitable position. Next is of significance, and for those who haven't come across this area before, and we'll explain this more fully in a minute, is that the right of recoupment and right of exoneration, there's two of them. One's right of recoupment for where the trustee has used their, I'll use it in simple terms, their own money to pay a liability of the trust, and they're trying to recoup money they've expended, where right of exoneration is they've just incurred the liability. So then that's outstanding, and which happens in the majority of the administrations, it's liabilities we're concerned with. So the real issue in these cases arises from dealing with the right of exoneration, and we'll explain that further.
So the nature of the right of indemnity shapes and informs the ability of the insolvency practitioner to exercise or apply that right. And as such, it only comes into play if, for example, there's a new trustee and they now hold the assets, the lien is able to be enforced in that circumstance. Or if the beneficiaries say, I want to be paid right now, the lien can also be used in those circumstances to protect that use of power. Now that was doubted by the Victorian Court of Appeal in re-Ameren, and in any event it appears that the High Court has said on multiple occasions that what it is in fact is a proprietary interest. It's been described in various ways, but the essence of it is it's some sort of equitable charge or lien, and it does afford a beneficial proprietary interest. But it is fluctuating and it's fluid, and it exists over the entirety of the corpus of the trust assets as they exist. Some of them may or may not exist. In this case, it's not general ownership. It doesn't purport to give beneficial title to a specific asset or assets, but it exists over all of them as they exist from time to time. And it's not an encumbrance, despite the use of the word equitable charge or equitable lien. It doesn't provide a security interest, and there have been a number of taxation cases where that has been so held. It's sufficient so as to render the bald description of trust property as being inadequate. Just what that means is still open to debate, and it has been used in subsequent cases to provide some sort of source of authority as to why non-trust creditors should have a right to it as well. The right of indemnity is inconsistent with this right of subrogation. To put things simply, if you have a debt that's owed by a trustee, you have a right to personally sue the trustee for that debt. You don't have any sort of direct recourse to the trust assets. But upon insolvency, or if there's a reasonable chance that you will not be paid by the trustee, the courts say that you have a right of subrogation to be in the position of the trustee to access the trust assets to discharge the liability that you're owed. Now, despite the valiant attempts by some creditors to seek to that point of time to apply directly to the court, and you do not have to wait until the insolvency process has occurred, but you can do it straight away. Now, what's the effect of insolvency on this right? Well, if there's a new trustee, and the new trustee has the trust assets in their hands, then what happens is all of the trust assets continue to be subject to that right of exoneration which exists over all of them on that fluid basis. What the insolvent trustee can do is they can apply to, again, a court of equity to seek to have the appointment of receivers or judicial sale of those trust assets. But interestingly, they can't seek the new trustee to pay them the assets so that they can hold them. The new trustee might be familiar with them because they caused a fundamental shift in the way that trust companies were wound up. And accordingly, what that means is that right of exoneration is not held in trust for trust creditors, and it's not held in trust for the beneficiaries either. Now, the effect of insolvency and bankruptcy is similar, say, for vesting in the trustee in bankruptcy, which occurs. It is something that forms part of the bankrupt estate that vests in the trustee in bankruptcy and is exercisable by him or her as part.
There can be terms in the trust deed which actually removes them as trustee, and that is something which has a fundamental effect for the purposes of realising assets for the benefit of creditors. So where a trustee or an entity is a bare trustee, its sole obligation is to protect trust assets. Again, subject to the issue that property is money, and there may be a power to deal with that, and that's in Kalani. If there's other property, the trustee can't just go and realise it. So, like an insolvency practitioner can't just go and realise property. A voluntary administrator or a trustee in bankruptcy court, one of the first things they've got to do is work out, firstly, whether there was a trust, and secondly, what the terms of the trustee provide, and to work out whether the company or individual, the company particularly remains trustee of the trust, because that will affect what happens during the course of the administration. Can I then go to the next issue? So if the position is that they're a bare trustee, the way to realise the assets, I use that in this term, is through realising the right of indemnity particularly by way of exoneration or recruitment. And as Mark said, one way of doing that is that the voluntary administrator or the liquidator is appointed the receiver. And that the critical feature is you've got to get the form of orders correct when you make the application. So there is again, one would then have to go to the court, particularly to exercise the right of indemnity through either the judicial sale or the appointment of receiver. And as identified down at the bottom of the page, of course, there's a risk between the time in which that application is made, where there's trust assets, that the trustee in bankruptcy should apply to the court for the appointments of either particularly receiver to realise the trust assets, and it's not a self-help remedy. I'll stand over to Mark now.
The next question is, how are realised trust assets, once you've got them in some sort of monetary form, how are they to be applied and distributed? This is at the heart of Reamarant, Ricolani and Lane. Now, as we said at the outset, the right of recoupment, because what you're in fact doing is reimbursing monies that you've already paid out of your own pocket, and there has been a very complicated and very conflicting jurisprudence, and Ricolani, Reamarant continue with that complexity. Historically, it was possible that the right of exoneration was able to be used to pay non-trust creditors. There's a High Court case from the very early 1900s, Savage and the Union distributed to non-trust creditors because the beneficiaries had no desire to see a particular liability be discharged. They were not concerned with where the payment went. And the reason we're here today is because it's been brought to a head again in 2017/2018. So I'll hand over to Paul to talk to you about Octavo and the cause of the confusion.
trust creditors and just creditors generally. So a lot of the times the courts were focused on what was the High Court saying? Is that they're saying trust creditors here and creditors there? Are they meaning creditors being non-trust and trust creditors? So a lot of time was spent trying to work out what the High Court meant. Just going back briefly, this was a preference claim through the Corporations Act provision that then was applying Section 122 of the Bankruptcy Act, because at that stage the corporations provisions incorporated the preference provisions under the Bankruptcy Act. There again, the liquidator sought to recover the preference, and one of the issues was, well, how do you recover the preference and what's the nature of the right? And so in looking at this issue, the right of indemnity was discussed, and in particular, as Mark identified earlier, being the nature of it being a proprietary right was effectively this process of reasoning to work this out. The court talked about and analysed briefly the right of indemnity and the position of creditors with respect to trust creditors, and this is why this has given rise to confusion, because the courts are saying, well, did Octavo, was it referring to the availability of payments which attract Section 122? So see the terminology, creditors generally rather than trust creditors. But when one looks at this case, there are only trust creditors.
Suggestion in Octavo that it was distributable to non-trust creditors, and in particular the right of subrogation would suggest that it's not distributable to them because they have no right to be subrogated to the trust assets. Of importance was also the fact that this right only exists because the trustee is indebted to trust creditors. Without those trust creditors, there would not be any right of indemnity. And so therefore, how can it be said that the non-trust creditors ought share? Now, following Reburn, we had the Victorian Full Court, as it then was, decide re Enhill. Now, re Enhill considered Reburn, it also considered Octavo and a number of other more historical Chancery Division cases, and came to the conclusion that it was creditors not be able to share. Justice Lush held slightly differently. He said that there was this special third right. So you've got the right of recoupment, right of exoneration, and then this third right, which enabled you to pick up trust assets into your own hands, hold them beneficially, and then use them to pay trust creditors. And because of that, he said that on insolvency, and considering re Enhill and Octavo and all the historical cases, and they came to a completely different view. They did so, again, primarily on the basis of that nature of the right of subrogation, being subrogation occurs and it was able to be exercised upon insolvency, but yet at the exact same time as we're saying that you have a right to be subrogated, we're saying that we're going to take that away and it's distributable to non-trust creditors as well. And they therefore held that what it is in fact the right to pay trust creditors purely from trust assets, and that's it. It has that limitation. There is no special third right to hold the assets beneficially. Now, Rusuko Gold has been and continues to be applied on a number of occasions. It was also applied by the...
So what Reunion says about the application of the proceeds from the realisation of the right of indemnity by way of exoneration is only dicta. And fundamentally, although the court analysed this in some preliminary way, the biggest point coming out of the decision, as one may expect from Victoria, is they said Victorian judges at first instance must follow re Enhill unless and until appellate decisions decide otherwise. Because this decision, in a factual sense, didn't deal with trust and non-trust creditors, with respect to the appeal going to the High Court, it's doubted whether this issue will be dealt with by the High Court, because it's just not something. Again, in this case, there weren't trust and non-trust creditors. Sorry, it's not available to non-trust creditors, so it's only available to trust creditors. But as identified at the commencement of the presentation, this case again only dealt with a position where there were only trust creditors. So the Chief Justice, particularly, even there's a judgment in the early part of His Honour's judgment, I think it's around paragraph 30, and as well as identified here, there were other parts of the decision that His Honour endorsed Resuco Gold and said that should be applied. And he gave some analysis for that as it's identified in the slide. But what that means is that we're still in this invidious position that
the first and only decision that I'm aware of, other than a decision in Re Matheson of Justice Spender, where this issue was actually considered. Justice Derrington there said that the comments in Octavo, due to the fact it was only a trustee company and had no non-trust creditors, that those comments were only supposed to apply with respect to trust creditors. But the underlying reasoning again is that same theme of the right of subrogation. You'll see in the third dot point that the right of subrogation would be rendered inutile if the right of exoneration met the claims of non-trust creditors. And accordingly, it has a limitation where it must be used to discharge trust liabilities, and because the trustee in bankruptcy takes the right of exoneration with all the limitations that it had in the hands of the insolvent trustee, then that limitation equally binds original jurisdiction and not its appellate jurisdiction. It's not binding either. And Re Enhill conflicts with Resuco Gold and all the weight of authority. So what to do, and I know that that might be a bit small, so you might need to look on the pages in front of you, but let's invoke the doctrine of precedent and try and work out what we should do here in Queensland. We should not depart from decisions in intermediate appellate courts unless we're convinced that they're plainly wrong. But here there's more than one intermediate appellate decision, so what should we do then? The next step is to follow the preponderance of it. But there's one from Victoria, being Re Enhill, and one from South Australia, being Resuco Gold, and all the others didn't actually directly consider it. So which one of those two do we follow? So the next step is we follow the later one unless it's an extreme case, whatever funds permitting, to apply to the court for directions in order to have that approval such that you're protected if you're an insolvency practitioner.
Big question. Does the priority regime apply, being a priority regime either under the Corporations Act or alternatively the Bankruptcy Act, apply to the proceeds from realisation of the right of indemnity by way, particularly here from exoneration? And that's, of course, considering the background of Octavia as we've identified on the slide there. Now, so it's property of the company. When you go, for example, to the Corporations Act, you'll see the definition of property of the company both under the DA section and as well through the liquidation section, so you can marry those terms up. So the thinking is then that the provisions of the Corporations Act must apply, otherwise the result would be inconsistent with the authority of the High Court. That's what was identified in Cameron. Justice Farrell agreed with the Chief Justice and ultimately Siopis did in the main areas. But their reasoning is quite interesting when you go to read it. That ultimately, through these decisions, the proceeds from the sale of the realisation of the right of indemnity would be available to the company. Because of time, I'll just go over to Siopis and then go back to Justice Farrell. Justice Farrell, Her Honour, had considered these issues before and was influenced by a decision she previously made in relation to this decision and these areas, and particularly she was equity would follow the statute immediately. So even outside of the statute, equity would follow the priorities. That's one of the reasons Veronica as well, and she was accepted that reason that was put up by the Commonwealth in relation to that application. I'll just go on now to the impact of the bankruptcy scenario, and Mark will deal with that.
Thanks, Paul. So there's a difference in the insolvency regimes, which I'm sure most people will be aware of. In Corporations Act, you're distributing property of the company. Between the Corporations Act and the Bankruptcy Act, that may provide some legitimate ground of differentiation, which means ultimately we might have a different scheme under one act compared to the other, which would be undesirable. But it did seem to His Honour that the same result should apply under the Corporations Act, notwithstanding the word proceeds was not used in that act. In re Amarind appeal, we had the full 5-member bench say that the word proceeds shouldn't be given the significance that Justice Derrington gives them, and that in their view the term proceeds seemed apt to describe what is the use of insolvencies. Now the question remains, at least in personal insolvencies, and potentially if re Amarind is challenged, what happens if it's not to be distributed in accordance with the priority regime? How do we distribute it? And given its fundamental nature as an equitable charge or equitable lien, it's enforceable in a court of equity, and so it needs to be distributed in accordance with equitable principles. And what that means is an application to the Court of Equity may be required, and the court would therefore make directions as to how it ought to be distributed. I'll skip over this very quickly. In the past 20 years, the general consensus is that trust creditors are paid pari passu from the right of exoneration. It meant that he was wrong as to the applicability of res suco gold and those principles, but he did raise a caveat, which is it wasn't squarely raised, and I'd like a full opportunity to be given to the debate. And now that's relevant for the doctrine of precedent, because it means that those words, even though they probably were omitted to begin with, are not in any sense binding on lower courts. Justice Iopsis remarked it would be open to a court of equity to follow the statute, at least with respect to employee entitlements and their priority. Whether the word open means a court of equity might be so persuaded in some circumstances or class and have been identified as such for such a number of years, equity would give them priority. Now, Justice Farrell, thankfully, to all the insolvency practitioners in the room, decided that insolvency practitioners ought also get their priority in equity, and that's because otherwise there'd be no one to do the job. But we reach this interesting conclusion once you accept potentially that employees might get priority, and you accept that hopefully the insolvency practitioner gets priority. What about all those other ones? There's a good 20 or so, and that a full debate hasn't been given to them. They remain interesting for now, but they don't provide, at least in our view, a proper basis at this stage to seek to say that equity would follow the statute. I'll pass over to Paul to say what all of this that we've just discussed about means.
Can I just before I do that, of importance, of course, to all insolvency practitioners is their entitlement to be remunerated their costs and charges for doing the work back. And I'm just going to let you know there's a seminar coming out. So going back to the conclusion, we've probably identified this in a number of ways, but again, using the principle of precedent, one has to think about, like, if I'm going to go to court, where do I go? What law is going to be applied? For example, do I go to the federal court? Do I go to the Queensland Supreme Court, which get before a judge making decisions that I've dealt with in the federal court there? But what this just means is that there's no clear answer. Mark and I can't come to you today and say, here's a clear answer. The only one I can say to you is if you're a bed trustee, don't sell the assets. That's, I can say, there's no dispute about that. But how you deal with them once you realise them, that's where you get the issue. So, but again, applying for remuneration, and which we're going to deal with later, that's added another complexity, particularly that's through a voluntary administration, etc. So, one would think when you apply, particularly the Supreme Court, if you go there on these issues about distribution and application of the rights of indemnity through exoneration.
Just briefly, what does that mean for personal insolvency? No, despite that, they've still managed to find a way to find that it's plainly wrong. So it might not be too hard to say that it's plainly wrong, and for Justice Derrington's decision in Lane to not be followed, especially in light of Kalani and Reamarant. Interestingly, Lane is currently the subject of a stayed appeal, and it's stayed because there's an outstanding judgment, but it's also stayed because of the Reamarant special leave application. So watch this space, because we may get some intermediate appellate authority in the personal insolvency space.
Just to having been dealt with by these three decisions, for example, in the LN investments matter, there were like 5 managed investment schemes and 5 registered managed investment schemes, 1 non-registered scheme, and as well the responsible entity. So there's a real complexity there as to how the matter was to be dealt with, particularly, for example, the way in which remuneration expenses were to be allocated. And for that reason, we've got a talk coming up in 2 weeks dealing with some of those issues. And as I said before, Mark and I have not dealt with the quantification of the right of indemnity issue, because obviously that's important, because that determines how much goes back to the company or the bankruptcy estate, and that involves looking at the clear accounts rule on how that applies. As I said, we just don't have enough time to deal with that today, so that's what
trustee of a number of different trading trusts, and I was of the view until the Reamarant and Enhill controversy was resolved that there might be an inherent danger in having a corporate trustee as a trustee of more than one trust, because the assets of different trusts could be made available for all of the non-trust creditors. Is that still a live issue?
I think that's a live issue if you apply remuneration. That's correct. But ordinarily, the way it would be treated is putting aside remuneration. Obviously, the trust assets would be realised and then applied to the creditors. It's normally equity is equality, so it'd be pari passu unless there's some justification from the departing from that. And again, that's what happened in LM to a slight degree, which we'll deal with. But ordinarily, I would have thought just the right of exoneration for the particular trust would only be available to those creditors in that particular trust, and not for all the trust creditors. Does that answer your question?
I think so. An unresolved issue there.
It is, particularly in what we use. I don't know if Mark's got any comment.
If you're in Victoria, definitely. If you're up here,
what about the ipso facto provisions and the fact that, you know, where an insolvency event occurs to a corporate trustee, they cease holding their office? Do you think the law reforms coming in relation to the ipso facto will mean?
I don't understand what you mean as part of the safe harbour provisions.
Yeah.
Came in there. I haven't actually specifically analysed that. My understanding is not, that won't apply, only apply in relation to deeds of trust after a certain date. I can't remember off the top of my head what it is. But I haven't looked at that provision to see whether that will apply to the ipso facto clauses in deeds of trust. I was going to put it to reappoint trustees to enable them to realise assets. So that does happen.
anything else?
You mentioned that rearmament doesn't decide the issue as to whether we can apply the right of exoneration to the benefit of all creditors. Is what
And accordingly, the special leave application might be allowed potentially on that ground.
We haven't dealt with that part.
You said you had the submissions or the application for special leave.
Yeah,
Does it deal with the second point?
yes, it does.
It
Because
does.
if you read the back of the judgment and reammon, it deals with the other issues about that.
Yeah.
Well, it's just circulating security interest in the previous point. So
I'll double check that, but I'm fairly confident that it did, and we just didn't include it in the slides because we weren't discussing that today. But I'll confirm that and let you know.
I've just got notice of people from one of the council was involved in it in Melbourne, so that doesn't mean that will be obviously the final version of the grounds. I can let you know that if you want, just send.
It's still as thick as clear as mud.
Indeed. I'll have to go away.